is POPI? I mean, we heard a lot about POPI during the discussion, the second panel discussion at the conference. But for purposes of what we're doing here, specifically looking at the impact on the contact center industry of POPI, please define POPI in its relationship specifically to the contact center. And let me give you each 5 minutes to do that. Margie.
Okay, I hope I don't need the full 5. In my understanding, and I'm obviously looking at this from an operational point of view as an operational service management and contact center expert, it is the legislative requirement that business and individuals respect the rights of privacy of any information that comes across their desk or across their in person of a third party. There are rules that are set out in place to say the information, first of all, the person needs to know that you're gathering and storing their information. They need to actually have a right to decline. They need to have a reason why you need the information. And you have a legal now obligation that you only use the information for the intent stated and for the permission given. And that should that information become obsolete, you actually delete it off your systems. You don't hold on to it, and you certainly do not pass it on. From an implication point of view, obviously contact centers are sitting right at the coalface of contact with customers, and as such, we actually, is our currency. Personal information is our currency. And we gather personal information all the time, from the simple asking you your name, what are your contact details, what is your policy number, etc., etc., etc. Usually it is actually at the trigger of the customer from a service point of view, and we actually are using it to assist the customer. The point being that as soon as we put that into our corporate databases, what happens to it then, and how is that customer guaranteed that that information is not abused?
All right, so thank you for that, Margie. Thank you for that. Let's move on to John then. John, specifically within the context of the contact center sector, how do we refine Margie's definition in terms of what the regulations and legislation says and what we're supposed to take out of it? John, are you there? Chepo, is John online?
Let me just see if I can get a hold of him.
Yeah. There's also horrible background noise.
All right, so guys, I'm just quickly looking to see if I can see whose microphone is on, and therefore who is. No, okay, there's no sound coming through. Can you hear me now?
I can hear you, Ivor. Yes, I'm the only other person I can see whose mic is on at the moment. Yours and mine. Okay,
so there's no background noise, so that's fantastic. All right, so guys,
good.
Is John on?
It seems that John has actually gone offline. I'm not sure if there's a techie problem there.
Okay. So Margaret, look, let's take this a little further then, and now let's move into the realm of the contact center sector. What specifically about the control or the gathering of information, the disclosure of information to start off with, the control of that information, the utilization of that information, and importantly, how one manages the obsolescence of that information? What should we be taking into account if we're a contact center sector in terms of walking on the right side of what could become quite problematic in terms of prosecution?
I think that I always try and visualize this, if I look at it from a business, a contact center operating inside of an organization point of view, I try to look at it as a funnel. And the real challenge for the contact center operationally is that we're at the top end of the funnel. And if you imagine the information comes in a very broad spectrum to us, and it filters through and it gets escalated through and drops down at the bottom of the funnel into our customer databases and other databases that we interrelate with. The challenge is that I believe the intent of the legislation is to protect against hacking and against distribution of information. We've all got our horror stories. We know of some recent horror stories in the public sector where this has happened, where people's personal information, and obviously controlling cyber fraud and all of those kinds of things. That's the intent. The problem is that we are the gatherers of that information. We have a legitimate purpose for use of that information, but there needs to be controls at every level behind us that the information is only used for that purpose for which there has been permission granted. And on an organizational level, I think that is very difficult, even for an organization operating in good faith, because of just human habit and the way humans interrelate and use technology and communicate through technology. So something as simple as I get an email from somebody saying, giving me certain information about a particular project. I have a question about another, and I forward that on, or I copy a third party into the question about the other without thinking. I've now exposed that person's personal data potentially to a third party without their permission. It sounds harmless, it sounds like an oversight, but technically that is in violation of the Act. So there is a massive need for businesses to, one, that they have systemic IT controls in place to protect and secure data on an actual security level, and they have to have a nominated person in charge of that. So there has to be somebody that can be identified and a process that is integrous that says nobody can just hack in and take anybody's information without any reasonable permissions being granted. But beyond that, on an operational level, as I understand it, and I think most companies that I've encountered have got that in place already, because this has been lurking around for years now. So most people have dealt with that type of technical side of things. I think there is an intermediate and then a frontline problem. If I deal with the frontline problem first, because I think that's the biggest for ops, call center, contact center people, there is a need for the business to show good faith, that they have informed every single representative in their business, employee in their business, of the Act, of the principles of the Act, and that those people understand that they have a responsibility to protect that data, and that they may not be negligent or indiscriminate. Excuse me. They may not be negligent or indiscriminate about the use of that data. So there is a legal and moral responsibility on companies to show good faith that they have made that effort. When you consider organizations like the cellulars and how many people you are needing to now demonstrate that you have reached, that they've got comprehension, that they understand, that you've done everything you can to ensure that there isn't abuse, that is a major initiative that needs to actually happen, and it's an ongoing thing every time you replace staff. So there's an integrity issue and a training issue and a communication issue that every operational environment is going to have to undertake. That is, I think, is seriously underestimated, and in my experience has not been done, and where it has been done so superficially that they would not satisfy an inquiry that they have met their obligation of good faith. The intermediary issue, which I think is of more technical but immediate concern to particularly the outbound contact center market, is there is always this lurking question of where the hell did these people get my phone number or my email address from? The buying of lists, the buying of numbers, the buying of data, the actual utilization of that data without direct consent, without actually the person having, and I think that there is already a fairly aggressive consumer who is really tired of being spammed and over-contacted. We oversubscribe. I think Truecaller said that we're the 5th most contacted nation in the world, which I don't know how accurate that is, but it's a scary stat because we're certainly not the 5th largest economy. And there is this aggression from consumers who I think are going to start biting back and saying, I never gave permission for these people to have my details. So where the hell did they get it? And there's going to be that nuisance value, which is really, I suppose, what I would call a revenge consumer who's now saying, absolutely stop it, I've had enough of this. So I think that the outbound section of our industry is going to be manifestly affected by this. It's going to cost them much more money, as it should, to actually get data, to make sure that it's clean, to comply with existing legislation that says, you know what, if I say take me off the list, then you have to take me off the list. They don't bother. I personally have not only verbally, but have written to people to say take me off your list, and they still contact me 3 times a week. So, there's a lot more. I think the POPI Act will come in to support a lot of other legislation in ensuring that there's a lot more penalty involved if people don't start complying in being clean in the way they operate.
Okay, so I want to ask a question, and John, thank you. I see you have rejoined us. So I'm going to ask this question of you. Within which call it collective organization, be it an association or the professional body, but within which organization would you see the accountability to the public in general for the management of POPI in each constituent member, each call center business which is a member of an association, or individuals who are a member of a professional body? Within which organization would you say accountability for how POPI is used in the contact center environment should vest, that the people of this country can know that that organization is accountable for its members, which are accountable to it, on the one hand, and within the organization, who should the POPI officer be in a contact center environment who's responsible for compliance? That's testing compliance, reporting on compliance. John, I believe you have rejoined us.
John, I see that your microphone is off. So if you just find the microphone button and click it so that it goes on.
All right, Margie, let me ask you the question until John is able to join us. Number one, John, are you there?
I am.
Oh, all right. So let me ask you the question again, and it's a two-part question. So the first part of the question, John, is which organization do you believe should be the accountable authority to civil society for how the contact center sector manages POPI, how it manages information from an ethics perspective, what scope of ethical considerations are being applied? Which organization would you say is best placed to be doing that?
Well, I think if you start with the organization itself, the accountability sits fairly and squarely with the head of the organization. So there's a role called the information officer, and that in the Act is defined as the designated head, meaning the chief executive officer or managing director or equivalent. They may have
all right, so let me challenge you there and say that I think we need an industry norm or an industry standard to say it is highly unlikely that the chief executive officer is going to be accountable for POPI or going to be the accountable officer. Even if they're legislatively that person, they have an obligation to delegate to someone who is more full-time, more committed and focused on management of POPI. So who should that person be within the company itself?
So the point I was getting to is that the Act does allow for a deputy information officer or deputies to be appointed. They can be appointed to manage a compliance framework. The CEO does not relieve, is not exempt from the accountability. So that structure does not change. It is a governance mechanism that cannot be changed. In the organization, the deputy information officer in a call center environment would be the head of that, the most senior manager, and would be responsible to the CEO for implementing, maintaining, and monitoring a compliance framework. So that is within the organization itself, and that is clearly what the law says. You mentioned the industry aspect of it. The Act makes provision for codes of conduct to be prepared and submitted for approval. Now, a code of conduct is a document that can be put together by the relevant industry body, and that would contain details of how personal information should be protected in that industry. So in the contact center industry, a code of conduct can be put together by people who are in senior positions in the industry body. That can be tabled for approval with the information regulator, Once that is approved, that would be acceptable as a code of conduct for the industry.
All right, so let me stop you there and say that from what you've said, from everything you've said, I believe that there are two accountable bodies that immediately present themselves. The one from a corporate point of view, let's say from the CEO point of view, from a general policy point of view, from a code of ethics perspective, would be the employer structure. And here we could be talking about the CCMG as that employer structure within the sector, which really is accountable for doing everything you've just mentioned. Whereas the second is the professional body that then says that from an individual perspective, every individual who is a recipient of professional designation would be accountable for an individual code of ethics, for an individual POPI set of considerations that they would be responsible to. Does that sound operational?
Look, I would hesitate to use the word individual code of conduct. There would be one for the industry, by which organizations, members of the industry body.
So we've got a number of industry bodies, but I suppose the CCMG is the ideal industry collective in that regard. But are you saying that if the company is held to a code of compliance, that is sufficient to keep the individual bound? Because I would argue it isn't.
Look, I think what would need to flow from that is the individual organization has to implement its own compliance framework. They have to maintain that. Now, roles and responsibilities for governance and management need to be established in those organizations as well. And that will depend on the structure of the organization.
Margie, what would you say about this discussion?
I think that I understand what John is saying, because he's looking at the letter of the law. At the end of the day, the buck stops with the chief executive, and he's going to be the guy who's held accountable for violation or non-compliance. But within the structure, I do think that the employment contracts, the performance contracts, and just as with any other compliance regulation, there needs to be a delegation of that right the way through the hierarchy. I think that what is, for me, and it's perhaps an operational rather than a policy concern, is the fact that I don't think that business is understanding the extent to which that goes down to the individual employee, as opposed to just in their hierarchical management delegation of compliance requirements. So I do think it needs to be written into contracts. I do think that that would be a logical place for it to actually go. But it actually also there needs to be evidence, because it's such a difficult thing to control. It really is. If somebody verbally gives you details, how the hell do you know that the person's then gone and given them to Auntie Mary, who's now selling them something else that's totally inappropriate? It is a very difficult thing to control, which means that the onus is on every organization to be able to demonstrate that they have done as much as they could reasonably be expected to do to control abuse. And I think that that is what is operationally being significantly underestimated. Have I answered your question, Ivor?
I think you have. Let's get to the issue of what happens in company. So a company has adopted a policy, either its own or one which has been determined by a collective activity that CCMG facilitates, so that CCMG can say we have a standard of compliance, we have a standard of implementation, and we have a standard of reporting. The company adopts that standard of compliance, implementation, and reporting. Yes. Who within the company becomes that compliance officer? So we've said in all likelihood, it's not going to be the CEO. It's from a day-to-day basis, it's even less likely that it's the CIO, Chief Information Officer, or Chief Technology Officer, who would have the time and the inclination to be that compliance officer. It seems to me that if one's comparing this sector to, for example, the financial services sector, where you find a compliance officer on the floor, on every trading floor, who is accountable to the Financial Services Authority, that level of scrutiny and compliance testing and checking doesn't exist at the moment within the call center sector. Would you at least agree with that?
I absolutely agree. And I think that you're absolutely right. I think that most organizations that have already enacted some kind of attempt to comply with POPI have actually done it at the data level, at the techie level, in the IT department. They have not actually rolled it through to the front line, and I think that it should become a minimum standard of basically in integration into training. So things like our unit standards and things which we all know are so terribly out of date needs to have a special section that actually talks to compliance, regulatory and compliance requirements, and it needs integration in there. And actually it immediately picks up at the first time manager, at the first point of management, that person is accountable for the people they manage, their compliance. I think the presumption is, because we're dealing with data, is that 90% of this is going to be tech-driven, which is probably not wrong. But I think that what that ignores is that I think violation or non-compliance in most instances is going to be through negligence or through lack of thought. It's that mindless or thoughtless, kind of forwarding on of something without paying attention to the fact that there's all sorts of data sitting below that message that would cause you to be in violation of the Act. But having said that, we also are smart enough nowadays to know, I certainly have had a number of examples across different industries and different contact centers where people have been coerced at the front line. Agents have been coerced into actually disclosing data to third parties outside of the organization for the overt intent of fraud. So they are vulnerable to being pressured into actually violating the Act. And so there A needs to be the right level of controls. There B needs to be mechanisms through which you can protect people should they get into such a situation. There needs to be reporting mechanisms that can actually trigger a fast and appropriate response. And C, there needs to be a collective and systemic approach to how data is managed, collated, stored, utilized, and cleaned and deleted. So we add in cleaned and deleted on. It is frightening how few contact center organizations who use contact centers as an instrument genuinely bother to clean and delete data. They just count on, the machine to plow through all the nonsense and just cancel those calls. They don't actually bother. And I think it's placing a much greiter onus on corporate responsibility.
All right, so let me come in here, Margie, and then just address a question to John. John, on the one hand, it's very obvious that companies regard their databases as virtual IP, that quite frankly will be theirs, that they can on-sell, that they can do with as they want. And more importantly, Margie talks about obsolescence, but in reality, the question is, if companies are not actively cleaning data, scrubbing data, renewing and refreshing data, then they're going to trade on the obsolescent data that they have on an ongoing basis. There doesn't seem to be an imperative legislatively for what they do with that data, or am I not reading this Act properly? John?
So, I think there are a number of aspects in the Act. One is about information quality. It's condition 5 in the Act, which really says that organizations need to ensure that information is accurate, up to date, and not misleading. So the accuracy, maintenance of currency of data is important, and the Act does actually talk. Second is that there's an underriding driver which says organizations may not keep personal information for longer than they need it for valid business purposes. So there's a retention aspect of that as well. So the tighter data management, personal data management, is really a legal obligation, both in terms of information quality and in terms of defining and really managing data around the defined retention period policy. So it is there. It does need to be respected and complied with.
Absolutely. It is absolutely there. So the Act has implied, in fact, it's quite overtly stated that information has to be kept current. And that introduces a massive exercise for a lot of people who are sitting with all this data on their database, that they have to have a routinized process where they actually verify that their information is still current. It also then talks to that it is that there's legitimate purpose to hold on to or to continue to use. And I think that those are the two key steps on a systemic level that 99% of businesses are choosing to ignore. And I think that you can't constrain business from operating, which means you can't constrain you can't create such rigid protocols of access to information of your own employees, which means you've got to also then deal with the reality of thoughtless utilization of that information at the employee level, and right down to the front line, to the gatekeeper level. So it is much bigger, I think, than business is really beginning to understand, even though it's not complicated. It's just volume. It's lots of stuff that's got to be done, and done routinely and regularly and on an iterative process into the future.
It just appears to me that we have this enabling framework which has now been adopted and accepted, quite frankly, because it's certainly not being criticized by any organizations within the contact center industry or sector. So the reality is there's work to do now, and the work is a set of collective activities to create the kinds of standards and protocols of application, the kinds of standards around the management and protection of data, the kinds of standards around the definitions of things like obsolescence of data and restriction on selling of data, and that is something which could very well be facilitated by CCMG of its member companies. What is interesting, though, is that a level of that standards development work would need to talk to the management of data, and therefore testing for the compliance with that standard on the management of data. And I would imagine that the vast majority of companies who are call center companies in South Africa would be averse and resistant to that level of intrusion. Now, if you look at the financial services sector, the way they've managed against that paranoia is that they've had an internal officer who's a compliance officer accountable to the authority. So let's say, for argument's sake, CCMG as an employer association, that being the authority for the management and implementation of POPI, where each participating company would have a compliance officer accountable to that organization, and then virtually on an internal audit basis be reporting and having their reports quality controlled with the least amount of intrusion into the company's operational process. That seems to be the smoothest way to proceed, and yet we haven't spoken about it within the contact center space yet.
And there too, my concern that if you go into most conventional organizations and you say, what are you doing about POPI? They'll say, oh no, we've done that years ago. We're still waiting. I mean, it's still in the ether, and we've done that years ago. We've got an information officer. They consider the job done. And I think that they've done the 10% and they've got the 90% to face. I think it's massive, and I don't think that they're being realistic about the potential. What is the likelihood that they're going to actually get nailed by the regulator? Probably fairly low, unless they do something really damaging. But the fact of the matter is, to comply in terms of the spirit of the Act, they've got a mountain of work that still needs to be done.
So can I come in and reinforce that? I think there is a lot of work to do, but it can be done if you look at the structure of the Act. There are 8 conditions or 8 principles which are based on European Data Protection Directive. And it's international practice, and I think once one understands and grasps those, the foundation of which are purpose and consent. So collecting personal information for a specific purpose with the person's consent are actually fundamental to doing most of the processes that organizations, including contact centers, will need to do in fact carry out. And those things are really paramount. And if one understands the other, and you've got, organizations need to understand the bigger picture before they start trying to put little bits of operational control in place. And that needs to really be driven and owned by an executive team. It is a strategic thing. It's to build trust. It is not to simply put a few tick boxes in place and say, yeah, we're good. And there's a responsibility on the information officer for ongoing training. And all these things come into a compliance framework which has to be established, maintained and monitored. Otherwise, a tactical approach is simply going to fail. And I've seen it many times. You can go through slogans, you're going through, through a few mechanical things, but when you really take a step back and ask what the organization's understanding, how it's practicing personal data protection, you actually find it's not a walk in the park. It's not a one-off thing. It's an ongoing thing. There's a lot of behavioral change management that needs to come into it as well. It's the start of a journey for protecting information, personal information of customers, prospective customers, and other stakeholders.
Can I get a feeling from the people who are involved in today's telephone conference, the 36 or 35 other people on the line, as to what your view is about a collective set of activities to manage POPI and potentially manage it as a center of excellence in our economic cluster of industries and sectors? Any ideas from the audience listening in on this conversation? All right. Well, if you do have an idea, please just press your microphone and we'll listen to you. Margie, maybe we can go back to you because you did want to say something.
Yeah, just reinforcing, what John has said and what perhaps I'm, reiterating. But it is the simple stuff that is going to make us most vulnerable. Let me give you an example. You go to a conference and you sign a register to say, I'm here. And you get your badge and you walk in the door and somebody walks up behind you and uses their cell phone to take a picture of the register. It's violation of that. Who's responsible? So something as simple as that technically is in violation of the Act. And you've got to rethink how you display, how you present, it will affect right down to that process type of level. I think the irony is that because we are adopting or we are following the EE, the people who I've seen or have spoken to who have got a greater level of awareness of this are the guys who are the outsourcers who are doing offshore work, for the likes of European or British companies, because they've got a compliance requirement in their contract. But what I've witnessed on occasion is that they are very rigid in terms of compliance related to that particular company and contract, but any domestic work that they're doing, they're not applying the same principles across to their own domestic stuff. So, they will happily get information to sell a product to somebody, from one source, and they don't get a response, and they'll transfer their person's information into a different product line and phone them 2 weeks later on a different source. So they actually are, cross-pollinating their data list for outbound calling. It's about changing the culture of respect for customer, for intrusion, for recognizing that people have that their personal information is, the individual has a say and a right to have a say in what and how it is used. And that is a massive cultural change that has to happen on a systemic level as well as on an individual level.
So, Ivor, it's Kerry here from CCI Contact Centers. And I think, Margie, you really touch on something there, because we obviously have a huge international, we've got lots of international clients. So the GDPR has been a very, very big focus for us. And then we've also got domestic, so we've applied. But I think what it comes down to is the maturity of compliance, risk and compliance, and information security in the contact center industries. So CCI has really bulked up these departments over the last few years. We've got a full-on risk and compliance department, and we've got a full-on information security department, which was not there before. And our skills come from financial services. So we are, we're on a maturity journey, and I think, there's a lot of things that we've done and we've had to change. Where other contact centers are in terms of that journey, I'm not entirely sure. But my experience in terms of information in terms of financial services is that obviously you would have your working groups, or you would have, your compliance institute, and as a collective in the contact center industry, we're sort of missing that.
Yes. And I think if you think, Kerry, about when the financial services legislation came down the line,
it was the same thing.
It was a
journey.
It was a massive upheaval in businesses, the focus on it, the priority on it. And that was just in one sector. We're now talking about, to me, a similar upheaval that is now across every single sector.
Yes, absolutely.
And I think it is actually more nuanced than, the financial services provided for that you could certify people and they would actually ensure compliance at the lower levels. I don't believe this Act is doing that. This Act is saying everybody who has access must comply. So I think it is bigger than the impact of, and I don't see that kind of response from business in terms of conceptual understanding that this is more than giving somebody the title information.
I think it's also what has not helped is the fact that this legislation is just dragging on for so long.
So
if it was actually just, because even us, they'll say, oh, but you can't do that in terms of POPI. And then I'm like, well, there's actually only a few bits of POPI enacted and, this part isn't. So until there's only a certain amount of POPI courses that you can go on. What attracted me here is that it was contact center specific, but I've stopped going to all the, all the law firms that are, because there's nothing more that they can tell me.
And the Act is very easy to read.
It is. So all of the things that John's saying is absolutely right. We've done all of those things. We've got those processes in place. But at the end of the day, who can you hold people accountable?
Because can I come in?
Sure.
Thank you, Kerry, for raising that. The regulator is a recognised body. They have very limited complement in terms of number of staff. But if a complaint is lodged with them, they will actually take it up. I'm actually involved in a complaint at the moment.
Oh, that's interesting to know.
Yes, but the Act, as you say, hasn't fully commenced, and the real issue is that penalties, fines cannot be applied, cannot be imposed at the moment. But they also need to talk to people and grill and question what measures they have in place for compliance. So there is life there. It's not what it should be.
So John, just following up on what you're saying then, is there a space, is there potential for CCMG to approach the regulator and say, we want to negotiate a collective dispensation for the contact center sector. We need you to give us the input in terms of professionalization and expertise. We will bring the companies to the table in such a way that we have a collective approach to it rather than necessarily an individual approach, which sometimes is very difficult in terms of the precedents that are set.
The answer to that is yes. I think CCMG is well positioned, and the Act and the regulator are certainly receptive to looking at codes of conduct for specific industries with representative bodies, and that is actually there. And in fact, on the 6th of this month, they held a workshop in Midrand, and they invited people from industry bodies to come and talk to them by appointment. So there is action in that regard.
In fact, as far as I know, the DMA was also actively drawing up and working with the regulator to draw up some code of conduct. So I think that there is absolutely space to do this.
I think there is, and the DMA did actually push back on a process that was tabled in the draft POPI regulations of 2017. They objected strongly because the requirements were over the top. They have been toned down, and there has been significant discussion between the regulator and the DMA.
But I think what's difficult, Ivor, is that you're never going to get away from what you have to do as an organization, and you do have to have those policies in place and those processes and those compliance frameworks, and it's a lot of work, So if it's guidance that people are looking for, that's one thing, or but you're still going to have to do that laborious kind of work at the end of the day.
Kerry, I completely agree with you. I think there are two pieces of this particular puzzle. I think the one piece of the puzzle is a general set of standards and operational guidelines for best practice, which can be done collectively, and then companies have to adopt that and implement it internally and map what they've got against those standards and guidelines on the one hand. On the other hand, I think that from a professional body point of view, there needs to be a level of accountability for compliance from the individuals who are professionally designated generally, but then also there needs, in my opinion, to be a compliance officer designation so that that compliance officer can be held to a standard of implementation, monitoring, reporting, and dealing with disputes which might arise. So I think it's a multi-pronged strategy.
Yeah, and I think that's where I say it's a maturity journey, you know, because if more contact centers had established sort of risk and compliance and information security departments, then they would have responsibility for these sort of things.
I think the operational work there is a department, and it's a cross-functional responsibility. It is not something that simply vests in one space.
No, absolutely, but it needs to be driven from somewhere.
Absolutely, it needs to be across, and it also needs a quality control and audit process in order to be able to show, you know, good faith and due care. And I think that the biggest impact that I think people have overlooked is that because it's actually relatively simple in principle, and it's really common sense, you know, common sense is just not so common anymore. It really is commonsensical on so many levels, but it needs to be an integrated part of the learning and development framework, and there needs to be a comprehension testing and evidence that every individual in the organization has been through, comprehends, and has been held accountable in some kind of way for compliance. Yeah. And I think that is both a process and systemically needing management, but it is also needing to take it to that individual communication level. And that involves business disruption, because it means getting access to people, talking to them, making them do tests which they hate.
Which we do. And I think another thing is that your information security frameworks then start to speak to this as well. So most of our clients ask us for some kind of ISO 27001-2 accreditation, you know, or whether it's in the US, they've got the SAS 70, now SSAE 16 report, you know, which all talk to security, information security, which I know is only one aspect of it, but it's a big aspect. And then obviously a requirement there is that you do your policy attestations or PCI. That's another one who speaks, you know, that speaks to the information security aspect. And then you have to do your awareness training on an annual basis and your policy attestation and the rest of it.
So there's a recent addition to the ISO 27000 family. There is a standard called ISO 27018, which is an extension to that for privacy management.
Oh, wow.
So it talks directly to GDPR, and it also talks to general data protection principles from a slightly broader perspective. It includes the framework, and it can be, if you have an information security management system based on the 27001 standard, it can become an extension to that.
Wonderful.
So, you know,
take that back to our information security officer.
You know, from a broader practice perspective, and I think it's something we need to think about. We're talking about our local law because it is a locally applicable law, and we do have to respect it and comply with it, more so when it does actually commence. But the bigger picture is, in fact, that we are a very immature country from a data protection and privacy perspective compared with Europe and other countries. So that leads me to the EU General Data Protection Regulation, which has international applicability. So if a contact center here provides services, processes personal information of EU residents, they actually are obliged to comply with that as well. You did allude to that, Kerry, but I think it's something, you know,
we're a data processor under the GDPR,
Correct. You know, so yes. So the bigger picture, the bigger international culture, the expectations are hugely important things. You do have to get down to the nitty-gritty, to the groundwork. Good news is quite a lot of the work between, you know, that has to be done for for the POPI Act and GDPR is the same, but there are differences, and we need to understand those. So,
and actually, I mean, the POPI is so closely aligned with GDPR, given that it is so recent. You know, in fact, I mean, it's actually more
based on the
exactly.
It's based on the predecessor to GDPR. It's based on the 1995 EU Data Protection Directive. So it is lagging, and it ought to be updated in certain aspects, particularly in things like social media and the advances in technology that have happened since that time. So, it does need a bit of a revamp.
All right, guys, so this is absolutely fantastic. I think we've got great insight into the topic. Can I ask, besides Kerry, who's absolutely hogged the floor in the conversation the whole time, is there anybody else on this call, of the 38 people on the call, who's alive and breathing, who would like to make a comment or ask a question? Nobody. All right. So, Margie...
I'll say that my colleague, Visa, who actually deals with the domestic arm, is also on the call, and she knows me well enough to know that I'm not one to keep quiet. So you're not alone in your views, Ivor.
It's great having you on. It's great having you on, Kerry. Okay, so guys, let me ask Margie and John just final comments before we end this discussion. Margie, from your side.
From my side, my area of passion is service operations. I think the outbound and the collections industry are in trouble. They are going to have to aggressively review their operating models in order to actually comply. Overall, it's obviously going to affect everybody, not just them, but I think they particularly are going to actually have to look at their ops models and review them quite aggressively. I think the second thing is that I personally believe that this is one of the best things that's ever happened to us, because reputationally our industry is taking a hammering. I think that we have been accepting of increasingly bad standards of practice, and I think that what this does is it starts putting a spotlight on some of those practices and starts driving us towards a more ethical relationship with customers, but also in a more ethical way of doing business.
And John, from your side, any final comments?
I think final comments from me is that I would encourage organizations to look at it strategically, as opposed to looking at it from an operational perspective. And it needs to filter down from an executive ownership perspective down to the front line, as Margie has said, but taking the bigger picture into account. There are benefits in doing it. It's not just a compliance stick, because organizations that do it well will benefit. They will build trust with customers, prospective customers. If they demonstrate that they've done a good compliance job, they will succeed. They will really create a business benefit over those who don't. So, I think regarded as an investment in business benefit, as well as something that needs to be done from a compliance perspective.
Guys, thank you very much. It's been a privilege speaking to both of you, and I trust and I hope that those people attending this discussion have got a lot out of it. I do think that we've got two people here, Margie and John, who would be ideal to consult on the application of POPI in your organization. And John, from a CCMI perspective, I hope you'll avail yourself to give a little bit of your time to help CCI interact properly with the regulator, and importantly, to collect the thoughts and priorities of the members of CCI so that they can be reflected in a common set of standards, principles, and best practices.
Hi, sorry, Ivor. Sorry, can I just jump in? Sorry, everybody is jumping at the last second here.
Shannon, thank you.
Hi there. Yes, hi.
Hello.
So just thinking of questions that you were asking about. So what I was wondering is, I work for an aggregation company, and I've recently moved to the UK. And just, Kerry and John mentioning all these ISO reports, I'm just wanting to try and get up to speed on these things, which is kind of why I was more interested in what you're saying about overseas things. And I was just wondering if either of you could point me in the direction of how do I find out more about these ISO reports that you were referring to?
I think one of the good resources in the UK is the Information Communications Office, the ICO.
Okay.
Great. They are probably the most mature regulator internationally in terms of personal data protection. Otherwise, you're welcome to look me up on LinkedIn, and I'll.
John, excellent, John.
Great.
Could I interrupt you here, John, and ask you if there's any chance you could send through a number of links to the various resources you've mentioned, and then what CCMG will do is put them up to all the people who are participating in this call, as well as your contact details in terms of internal facilitation. Guys, thank you everybody for attending. Thank you for participating, or at least to Kerry and Shannon, who were brave enough to step forward. Thank you both for participating, and we look forward to the next webinar for CCMG. Thanks very much, everyone.
Thank you.
Thank
Bye,
you.
everybody.